did the government impose more restrictions on religious facilities or places of worship than on other places where people gathered? Anywhere where they did that, you have to have a pretty strong bit of evidence coming forward to conclude anything other than that there was a lack of minimal impairment in that. There's an interference with religious freedom that can't easily be justified if you're interfering more with religious gatherings than with equivalent secular gatherings. I'm glad that some of the US courts asked that as clearly as they did, and I wish we'd seen more Canadian courts get into that kind of question.
Well, welcome everyone to Freedom Feature. I'm Barry Bussey. With me today, I have Dwight Newman. Dwight is a professor of law at the Canada Research Chair in Indigenous Rights in Constitutional and International Law at the University of Saskatchewan. And Dwight, it's a great pleasure to have you with us today.
Well, it's good to be with your program today.
Dwight, let me tell you, I just so you're out in Saskatchewan. Are you from Saskatchewan?
I did grow up in Saskatchewan, yes, and came to some of my schooling here. I started out at the University of Regina, but then law school at the University of Saskatchewan, and then I was out of the province for 6 years. Doing some work and eventually graduate studies. And then when I was looking for a faculty position, ended up getting a position back in Saskatchewan and joined the faculty here in 2005.
So you've been there now, 2005. That gives you like 17 years there almost by now, I would imagine.
It does. Yeah, time goes fast sometimes. I still feel like I'm just starting, but the time has flown by.
Yeah, it is amazing. I look back, I remember in the day when 30 seemed old. And then when I had the roughest time on my 30th birthday, that was for whatever reason. And then now I'm well past my 50th birthday. And it's like, my word, where has time gone? But Dwight, it's just great to have you with us. And I'd just like to let our listeners know that you are a constitutional scholar. You have been quoted many times in Supreme Court of Canada decisions, and it's a great privilege to have you here now talking about a publication that you've just had published, Reasonable Limits: How Far Does Religious Freedom Go in Canada? And I'm wondering if you could just unpack that for us, for our listening audience, who many of them may not understand the intricacies of law. But you raise some great points about reasonable limits and how the court arrives at reasonable limits. And maybe you can just unpack that for our audience today.
Okay. Well, there's quite a bit to unpack, so I'll do the best that I can. But basically, when we talk about the term reasonable limits in the Canadian legal context, this is a term that it's attached to Section 1 of the Canadian Charter of Rights and Freedoms, which is a section that both guarantees rights, but also says that they're guaranteed only subject to reasonable limits prescribed by law. And those words have been given meaning in court decisions. There are longer traditions on what reasonable limits might be, or the idea of proportionality and so on. But thinking of the legal meaning in Canada today, the courts have ended up developing a test that was based on tests in other jurisdictions that used similar kinds of analysis or similar wording, notably Europe. This was a contrast to the United States, where the limits on rights are sketched out a bit differently. But then in the Canadian context, those words have come to imply a specific test on government limits imposed on rights and freedoms under the Charter. And in essence, this test, called the Oakes test, sees the courts asking for fundamental questions about a government limit that's imposed on a right or freedom, in order to determine whether that can be a justified and accepted limit, or whether it cannot be. And so they're asking, is it a sufficiently important government objective that would justify limiting rights? They're asking about something called the rational connection component, which is whether the way in which the government is limiting rights is rationally connected to achieving the objective that they claim that they're trying to achieve. And that should usually be met. I mean, you hope there's not too many totally irrational laws, but there have been laws that have failed even that step. The big step that arises the most often is a step often called minimal impairment. And that's not necessarily to be taken totally literally, because if you took it totally literally, the courts would be asking, is this the absolutely least rights limiting way of achieving the government objective? And that's something that's sort of beyond the scope of courts to be able to assess perfectly. But they can ask questions on, is there another reasonable way of achieving the same government objective without imposing limits on rights or freedoms? And so they're looking with a bit of deference based on the institutional limits of the court, just meaning that the court isn't able to test out every possible competing policy with minor variations. But if there's some other obviously different way of achieving the government policy without having to limit rights, then the limit on rights shouldn't be accepted. And that's one of the fundamental parts of the test, and probably the part that laws fail on the most often if there's an issue there. And then there's a final step just asking about the overall balance of advantages and disadvantages of the law, in a sense, in terms of the impact on rights considered alongside the objective. And so even if a law passed all these other prior steps, they could still say, well, at the end of the day, it limits rights too much for what it's worth. But that again tends to be a less used step. And the key part is that question about, is there another way of achieving the same policy objective without having to limit rights as much? And that's something then that evidence needs to be presented on before the courts when they're analyzing this. There's some implications that flow from that. We can come to those, but that's the way the courts approach this.
Okay, so just so that everyone is can understand, we have the Charter of Rights and Freedoms, and we'll put that up there for you, so you can see that all of the rights have been granted subject to limits that are prescribed by law that are demonstrably justified in a free and democratic society. And then what the courts have done is they said, okay, well, in figuring that out, as Professor Newman so articulately put together, we've got 4 questions that the courts are trying to deal with. So they are pressing and substantial objective of the government when they are infringing on those rights, that there's a rational connection or objective with respect to the law that they pass that infringes, and that there's a rational connection, a minimal impairment, and finally there's a balancing, whether or not the effects of the harmful effects outweigh the benefit, as was pointed out, the final balancing. So that is how the charter works. And so a lot of people think, well, when you get the charter, well, you got those rights and we're able to stand up and nobody can touch them. Well, that's not how it is. There has to be a limit. Now, can we just talk for just a wee little bit about, why is it that rights need to be limited?
Well, it's something in the nature of rights themselves that they can't be unlimited, I guess. They exist alongside other considerations in society. impacts upon other people, most notably. And so governments do need to be able to identify limits on the scope of rights. Because if one person could claim unlimited rights, in essence, they would end up depriving other people of rights in the process, not through a government action in that case, but through the individual being able to claim rights that effectively ruin the prospects for others to have rights and freedoms. So it's really about valuing everybody in society in some ways, to recognize, yes, everyone has rights and freedoms, but those may be subject to limits for the sake of very important government policies that often would be geared to protecting people in various other ways. And so one could make the point also about just one right can't be so large that it wipes out other rights, even by the same people, in a sense, these sorts of considerations. And so we do need to recognize that rights aren't unlimited, or we get to sort of an incoherent situation where one person's rights could wipe out their own other rights as well as the rights of other people, at least in effect.
Good point. Your paper points out the problem with polarization, and that it strikes me that you raise a great point here with respect to this, because in trying to establish what are the appropriate limits and so forth, we are, it seems that our society is becoming more polarized. Can you speak to that just a wee bit as to what your concern is there?
And I mean, in writing about reasonable limits on rights, there's a worry that I come in and make nobody happy, because in a sense, the paper is saying to those who might think that a particular right should be unlimited, that it is going to be limited. And people who think a right is valueless need to recognize that right, and recognize that there are ways in which there's a coherent way of identifying reasonable limits on that right. Well, those two sides sometimes speak in very polarized ways, and people want to talk about a particular right or freedom, or just another issue altogether, and they come at it from positions where they assume that there's an all or nothing answer on a particular issue. And so one side has one extreme position, the other side has the other extreme position, and we need to find ways to live together. I mean, this is an obligation vis-a-vis neighbors that disagree with one another on some things, but need to live together. And an approach related to reasonable limits on rights is one of the ways that the Canadian Constitution actually provides for that in some ways, that it, as I say in the Section 1, it both guarantees rights and also recognizes that they would be subject to reasonable limits. But on a topic like religious freedom, there can be very well-meaning people who are arguing for the maximal scope of religious freedom in a particular context. And there are very understandable reasons for that. This is a vital freedom in any free society. But if people forget about the possibility of reasonable limits at times, they end up stating a position that goes further than what the law will protect. At the same time, there's a real danger on the other side of people that just want to reject religious freedom altogether today because they see it as not having any limits. If everyone recognizes the reasonable limits analysis, I think we can actually find a way past a lot of polarized issues where people have all or nothing positions, and we can find ways of living together with neighbors in much more successful ways.
It seems to me the important thing is that we're we recognize we're on the same piece of real estate that we call Canada, and we are occupying the same space. We need to be able to ensure that we can get along, even if we agree to disagree. And that's so fundamental with respect to that. One of the things you pointed out in your paper as well, there's a distinction that the court makes, and we will come back to the Oakes test. But one of the things you point out is how the courts treat administrative decisions differently. And that has been a problem that I have wrestled with myself as I've been looking at the various decisions. And what I want to explain to the people at large is that the Supreme Court doesn't use this Oakes test, the proportionality test that we have just been talking about, that has the 4 parts, in every single case. What they've done is they've said, okay, if you're right, and in our context now we're talking about religious freedom, if your religious freedom has been limited as a result of an administrative decision maker, and by that we mean basically a bureaucrat or a administrative tribunal like the Human Rights Tribunal or some other pension review board or whatever it may be, it's not a court, but it's a government agency, a government actor is the term we often use. Then in that case, the court has a very different analysis. So we've got a kind of a hybrid system going on, because in reviewing those decisions, the court doesn't use the Oakes test that we just talked about. And so I just want everyone to understand that we've the complexity here is that we have the Oakes test, which the courts have used for many years, but now relatively recent years, we've got what they call the Doré test, as a result of the name of a case out of Quebec, Doré. And I'm wondering, Professor, if you could just outline exactly what that test is all about.
In some ways, this would be a wholly separate discussion. But in simple terms, the Doré analysis sees the courts looking at whether they think administrative decision makers, bureaucrats or boards or so on, as you've suggested, have approached reasonably the balancing of rights, and have themselves looked at this in some reasonable way, in a sense. And there's a more specific legal test to this, but what it amounts to is that the courts aren't themselves seeking to carry out the Oakes test analysis so much as just to say some other decision maker has been tasked with that, and they're only going to review it if certain criteria of doing that very unreasonably have been met, in a sense. And I think this is a problem and has received a lot of critique, because in essence, the courts are filled with trained people, legally trained people who are there to carry out the kind of rights analysis present in the Oakes test. And you can agree or disagree with a particular decision that human people reach in such an institution as well. But they have that kind of background. The administrative decision makers, it can be much more variable what the background is, but they are nonetheless being tasked with carrying out, in essence, a decision about how to protect charter rights or not, with the courts showing a lot of deference or respect for that process. In principle, another decision maker should be thinking about the Oakes test and how it applies, but then the courts aren't directly considering whether they did that correctly, so much as whether they did it reasonably, and you can get some strange results that come out of that. And as I say, there have been some good critiques of the Doré analysis in recent years. I don't know if it will survive in the coming years or not. There's a little bit of case law that's even started started questioning it. But we'll have to see what happens with that. And that's a whole separate question, not about reasonable limits on rights so much as around when courts should be the decision makers versus when other decision makers carry out the analysis of reasonable limits on rights. And a lot of complicated things to say there.
Okay, so let's get back now to the reasonable proportionality tests that we have. Maybe what I should do, I'm just wondering, we've got a kind of like an overview already of the four parts, but let's have a look at some of the religious cases that this test has been used. There's been cases like, for example, the Amselem case out of Quebec, which is an interesting one, where there was a Jewish individual who wanted to have that sukkah hut put on his balcony, and that was violation of the condo rules. And as you rightly point out in your paper, this is really, this comes under the Quebec Charter as opposed to the Charter, the Canadian Charter. Yet that case, nevertheless, has made a major impact on the Canadian Charter analysis as well. And so, can you just kind of quickly outline that case and as to how the court dealt with that one?
Sure. So I do want to emphasize that case pertains to a decision under the Quebec Charter. And what's different in that context is that the Quebec Charter applies also to private action, where the Canadian Charter is applying just to government action. And so that's why the decision of a condo board could be subject to analysis for whether it violated religious freedom, where that wouldn't arise in quite the same way in other provinces. Human rights codes could enter into the process, but the way they analyzed religious freedom in the case has ended up being very important for how religious freedom is considered under the Canadian Charter of Rights and Freedoms as well. And in this case, they were actually quite skeptical on whether there was a sufficiently important reason for limiting religious freedom. The obligation of constructing a temporary sukkah during a 9-day Jewish festival of Sukkot was time limited, and partly as a result of that, the court ended up saying that a limitation that said that Jewish residents of the condo building that took the view that they needed to construct these sukkahs on their balconies weren't so harmful to the rest of the building that they needed to be limited, I guess. And they were skeptical on whether there was a sufficiently important reason for limiting religious freedom, and that would be an example of a case that would fall under that first branch. The main thing Amselem is cited for is the subjective approach to religious freedom, more so than as a case about the Oakes test. So I talk about in the paper in relation to that branch of the Oakes test, but it is a case that emphasizes that what religious freedom protects is the subjectively held belief, the sincere belief of that has a nexus with religion, as the test is sometimes put. And that's a really important conclusion that comes from the case, because it says that your religious freedom claim, as long as it's sincerely held, doesn't depend upon that claim matching exactly with an institutional approach to religious freedom, in a sense. So if there are different groups within a religious tradition who take different interpretations of some element of religious practice within that tradition, they can all receive protection. There's not going to be an approach that's based on saying that someone has authority to determine the religious tradition for purposes of court protections, as long as there are people that sincerely hold a belief in other interpretations of that tradition. That's the main thing the case is cited for. But in terms of the Oakes test, it is an example where a particular restriction on religious freedom just didn't have enough of a reason for it to be imposed, and the court was thus ready to reject it on that basis.
Okay, so that's the illustration of the first branch. Now we come to the second branch, that is rational connection. And there, of course, there is just this one case you make reference, where there was a situation where there was no rational connection when it came to the issue of citizenship. That was, as I understand it, children were able to receive citizenship with respect to their father, but not with respect to their mother, and that was seen as being irrational. So that section is not one that gets a whole lot of attention in the test. Isn't that how I understand your paper?
Right. I mean, it receives attention as a step within the analysis. But there aren't a lot of laws that have been struck down as lacking a rational connection. And so, again, what we're asking for is, does the government restriction question, the government restriction on a right or freedom, does it advance the objective that the government has set out to pursue? And I mean, normally governments passing a law to pursue an objective pass a law that does pursue that objective. I mean, if it's a misguided objective, well, that's a different problem. But unless they make a serious mistake, the law shouldn't fail at this step. But there have been situations where it has, and you've mentioned the case I referenced around citizenship requirements, or a government could just get things wrong and develop a law that's counterproductive in some way to what they're trying to do because of some aspect they didn't consider. And if so, they could see the law struck down under this branch, but it's a less used branch.
I want to just go through the other two relatively quickly, because I want to have your thoughts with respect to the other matters where we've had some issues. For example, the Canada Summer Jobs issue, the COVID-19 policies. And so for those of you who are watching this and you're saying, wow, these lawyers are just getting into all kinds of technical arguments here. But we'll just skim through it here real quick, and then we'll get into some of these other issues where all of this kind of makes sense, and where we are trying to wrestle through the challenges that the law faces with respect to the Charter Challenge. Okay, so the third component is that of minimal impairment. And then basically, I'll just, if you want to just say a little bit about that, but also about the Multani case, which I think in some ways is kind of like a high watermark, it seems to me, of religious freedom.
Minimal impairment, as the title for this step, I want to emphasize again, the key question that they're asking is there some other reasonable way they could achieve the same government objective while limiting rights and freedoms less? I mean, that's a really good question to ask about a law if we're concerned about rights and freedoms, because if the government can do the same thing without having to limit rights and freedoms, then why aren't they doing it that way? That's a really good question to ask about a law. I'll also say there's an implication that's directly relevant to the COVID context that would flow from that. In asking about minimal impairment, an implication would be that you shouldn't, in the context like COVID, have more restrictions on religious facilities than on equivalent secular facilities, or you're not achieving the objectives in a minimally impairing way. You could have additional restrictions on facilities that have a non-religious purpose, and achieve some of the reduction in disease transmission that was allegedly being achieved through the restrictions on religious facilities. And that would be something that just raises real questions about law. We can come back to that, but I'll say that flows directly from minimal impairment. In terms of the Multani decision, which isn't about COVID, obviously, this is an older decision from 2006. The Supreme Court of Canada there considered a prohibition on Sikh high school students possessing kirpans, that are a type of ceremonial knife, within certain portions of Sikh tradition, and they had to consider whether this was whether a ban by schools on those Sikh students who would carry the kirpan was acceptable. And they ended up saying that there were alternative ways rather than a complete ban to ensure that kirpans were possessed in a way that minimized risks of their misuse. And so this was an example of a case where they were ready to question an absolute ban in favor of saying, well, there would be a different way of achieving this, a more nuanced way of achieving this. And as you say, that marks a bit of a high watermark, that they were ready to get into that question a little bit, even in a context where they were questioning the decision of an administrative decision maker in terms of the school system. And this was before the Doré analysis was having all of the problematic effects we were talking about earlier on. But in this case, they were ready to say, well, did you need an absolute ban on this practice that has religious significance when you could have more nuanced rules around it that balance different objectives? And I think that's a good question for courts to be asking, and it's a question they were ready to ask in the Multani decision.
Which unfortunately they haven't been asking too much of late. Just 4 years later in the Hutterian Brethren case, they took a different approach.
Yes. So the Hutterian Brethren case, I mean, one can hope it's a low watermark of sorts, but it's certainly a case that's received a lot of criticism from religious freedom scholars, I think rightly so. It's an example of a case where one part of a religious community took a different interpretation of a particular issue, and that should be allowed under the Amselem decision. But I say that to emphasize it pertained really to a couple of hundred Hutterites in the province of Alberta, out of a much larger group of Hutterites in the province, who took the view that they couldn't have their photos on driver's licenses because of the prohibition on graven images. And that wasn't the view of all Hutterites, but for some. And the majority was ready to say, well, there couldn't be, the majority of the Supreme Court of Canada was ready to say there couldn't be any accommodation of this because it would affect the security of the overall driver's license system. There were some really good dissents in the case that said there would be alternative ways of accommodating this particular belief held by a couple of hundred people. This wouldn't bring the system crashing to a halt to find some reasonable way of accommodating this particular religious belief. And so, as I say, the case has received a lot of criticism. It saw the court wrestling with what the Oakes test meant, with some of the judges even urging some larger changes to it. But it's also a case we've moved on from, and hopefully can just put in the past and carry on with the analysis in more robust ways than perhaps we saw it applied in that case.
Yeah. And unfortunately, that one was also referred to in the 2018 case of Trinity Western, but that was under the Doré analysis. We won't get into that one. Okay, so we're going into the final one, is that of balancing, and here you rightly point out that the issue is whether the overall detrimental effect on the rights were excessive in relation to the policy objectives achieved. That's what you point out with respect to that fourth one. And I'm just curious, and I haven't prepped you before on this question, but I was just wondering about, when we look at just recently we know that the action of the Prime Minister with bringing into the Emergencies Act, but it strikes me that given the fact, first of all, I would say that the whole Oakes test will be interesting to see how that's going to be analyzed by the courts, because I understand Alberta is dealing with a court action on this. I believe. Am I right on that? With respect to the use of the Emergencies Act?
They've indicated that they're pursuing a court action on it, as have some other public interest litigation groups. So there will be several challenges to the use of the Emergencies Act.
So it strikes me that this one is going to be well, first of all, you've got the minimal impairment, which would no doubt take up a lot of discussion. But also it seems to me that the final part of the Oakes test may well come up in discussion by the courts in the Emergencies Act litigation, I would think. I don't know.
It could conceivably. I mean, some of the challenges to the Emergencies Act are going to be just about whether statutory conditions were met, so those within the law itself. If the courts get beyond those to some of the charter issues raised by the use of the Emergencies Act, which are being litigated by some of those that are litigating on the issue, this would be amongst the issues they could get to. I mean, you could ask first, was it a minimally impairing way of addressing protests to take the steps that were taken? So they might deal with it at that stage if they were to be skeptical on that. But even if you thought it was the minimally impairing way, you could still end up in a question where there are overall detrimental effects to doing it. That would be the kind of question that fourth step would call upon the courts to ask.
Let's go to some of the other issues that you raised, which I think are so important, of trying to be able to figure out, okay, what is reasonable in the situation? And you have highlighted the Canada Summer Jobs issue, and I wonder if you want to just unpack that for us.
The Canada Summer Jobs Program issue arose a few years back now, first in 2018. And I don't want to oversimplify some shifting things around it, but in various ways, qualification for the Canada Summer Jobs Program, which had long existed as a program to support student employment in the summers, or youth employment in the summers, was made subject to requirements that organizations participating in it sign statements about their adherence to certain views, essentially. And this raised major issues for organizations with religious purposes, amongst others, and questions about just why they needed to agree with the government on some contested issues. But there have been slight shifts in just how those requirements were framed over time. So there are more complexities one could get into on this if you were carrying out the full legal analysis of it. But in essence, that's what's at stake. There have been some court decisions on this that have been based on the area of law called administrative law, which is a bit different than constitutional law. Some successful challenges. The government was in some ways forced to change elements of what they were doing. But if it were to face direct charter analysis, I consider that a bit in the paper. And the idea that the government could say you can't hold differing views on some of these kinds of issues and still qualify for the summer jobs program, I end up suggesting would involve unreasonable limits on religious freedom. Now, that's not been litigated in a case, but I guess there's several different reasons we could question this kind of program. One is it comes very close to saying that there simply can't be particular beliefs, and that's just not an acceptable purpose for a law. It's an unconstitutional purpose in some ways, and so it could fail at the first step of the analysis. Whether there's a sufficiently important objective. Well, an objective of limiting rights isn't important enough. It doesn't qualify as a pressing substantial objective, according to some of the jurisprudence. But I guess there would also be questions about, in terms of whatever objective the government's trying to achieve through that, why does it need to be through requiring organizations receiving very ordinary subsidies on jobs to make attestations of views on particular issues? That is very questionable as a way of achieving a government objective that's as minimally impairing as is required under the Oakes test. There are various different problems with this, and the idea of just governments quashing dissent on contested issues in order to try to secure ongoing support for particular legal rights just doesn't pass various elements of the test. And so were this to go to a full charter analysis in some context, I suggest that the reasonable limits test has major implications for that program.
That's a very good analysis. I've often wondered, like, I mean, how is it that we've even come to this situation where we have our government basically trying to force an ideological position on, as you point out, very contested issues. And it also kind of shows a bit of a kind of a cultural context right now where I know a lot of scholars, or at least some scholars, have argued that even the protection of freedom in a constitution is something that is redundant, that should be really considered under the umbrella of freedom of speech and that kind of stuff. And so there's this mindset within the legal academy, it seems to me, that is really very much, one would hate to use the term anti-religious, but there is nevertheless a sense of a pushing down of religion that they don't want it to be given the prominence that it is, and in our Constitution. And that is where I think one has to really take some time to step back and begin at questioning, like, how is it we've come to this kind of situation that our own government is trying to force a view that really has rankled a lot of people? It has really caused people to put their backs up, and it's an unfortunate situation in just in the whole nature of governing, it seems to me, and one that hopefully, as time goes on, the courts will step in and be a bit of a buffer between the government and the citizens who hold very strong religious positions and are not at all hateful, as the government in various iterations would seem to suggest.
Various forces of secularization that have affected Canada in some respects do have implications, because a lot of academia is very secular today in Canada, and a lot of government decision makers are very secular, and even sometimes to understand well the claims of people from different faith traditions is a challenge for those that just don't have any background in those anymore. And there can be just misunderstandings that arise and misportrayals that arise, and consequences that flow from that. So these broader questions about how does religious freedom continue to receive protection in the context of a lot of elite groups, especially in Canadian society, being very secular, presents a lot of important questions in a cultural context that do have implications down the road. But the Constitution is there and meant to be a protection from that in some ways. The rights are there, but as you say, there are people who even are writing and questioning whether those protections should be there. And I don't want to say that that's the dominant view in academia, but there are academics today putting that view in a way that I'm not sure we would have seen at some points in time. And so there is a challenging position for religious freedom today. But there's also always reason for hope and reason to keep pursuing that discussion of why religious freedom is important and speaks to the very essence of being human. And there are lots of reasons, and lots of people who will keep putting that view, but a challenging position today for sure.
Yeah, I had a discussion last night on whether or not whether or not the office of prime minister is too powerful, and it strikes me that I appreciate Ian Brody's work, who suggests in his book At the Center of Government, well, this argument, the idea that the prime minister is a dictator, is a little bit overdrawn. It's overreaching. But when you step back and you think about the cultural context, because here you have an interesting alignment, it seems to me, that kind of brings up the idea of power, and that is, you've got an academia that is very secular, you have a government that is very secular, you have the media that's very secular, you have the legal profession itself very secular, and we've seen that in spades, I think, over the Trinity Western University cases. And so there's kind of like an alignment, like a hegemony, where everyone seems to be in sync. And so therefore, when you get people who are outliers, i.e. those who follow particular religious views and on various issues that the government is particularly interested in, which is what happened with the Canada Summer Jobs, then it's kind of like we're in a situation where everything is aligned, and there's almost like for a lot of people saying, well, okay, so where is the protection? And we have it in the Constitution, right? We have the Charter, which is meant to hold back against this kind of an alignment. In the same way, then, it seems to me that those who are of strong religious views is to be able to use, perhaps in conversation with the secular groups, to be able to say, well, can you imagine a situation if it were reversed? If the prime minister was very religious and held to these very conservative views, the academia in all of the universities and the law schools and so on were very conservative in their views. The media was very conservative in his views. It's kind of like, if the shoe was on the other foot, would you not feel like a little bit uneasy? And it seems to me that somehow we've got to be able to help the other side, as it were, for each the side that's currently now in dominance, to understand the minority, and if it were to switch, for the same thing to happen. It seems to me there's this element right now where we've got that hegemony, and everyone is got those positions, and it's hard to understand the other, it seems.
Indeed. And flipping things around like that is a very important way of trying to communicate these issues to people. These principles in the Constitution are about how people of different viewpoints and different worldviews can live together while having freedom for each. And I mean, even something like religious freedom itself. People of different religious views disagree profoundly with each other and think that there are major problems in the other religions if they're serious about their religions.
Yeah.
But they can respect one another in being in a common religious quest. And most significantly here, they can respect the religious freedom of everybody. That religious freedom is for those from all traditions, precisely because if you want respect for your religious freedom, you have to have respect for the religious freedom of others, on that basis of what if the shoe were on the other foot, in a sense. And so these kinds of questions about how to have a legal system that isn't dictating things to people beyond the scope of what a legal system should dictate. That's the really important question. Having freedom for people to do the things that people should have freedom around. That's a really important dimension to all of this. And I mean, one optimistic note I'll throw in is that around some of these policies, there was a clear sense, even in circles where you didn't expect it, that government had overreached. And something like the summer jobs program, there were people that didn't pay attention. But to be fair, I think even the op-ed people at the editorial board at the Globe and Mail were ready to call out the Prime Minister on this. And it's an example where there's been government overreach. And there have been some pretty serious questions raised about some of the government overreaches that have occurred in recent years. And that's something that calls for a little bit of optimism, even amid a challenging situation.
Right. That's our white pill. Okay, so what about the situation in Quebec right now? And then, just for our viewers, as soon as we're done that discussion, we're going to get right into COVID. Okay, so what about the situation in Quebec, where we've got this bill that's very secular law that's causing a lot of problems for a lot of religious minorities?
So, I mean, this is a law that comes from a long and very different debate in the context of Quebec about the concept of laïcité or secularism as a policy within government. And the law directly limits religious expression by people working in a variety of public offices, so that people working in these various offices listed in the law are prohibited from wearing religious symbols during the course of their government work, and have various restrictions put on practices that would evidence what religion they're from. Now, in the Quebec context, they take this idea so seriously that they've been ready to use the notwithstanding clause in the charter, which is a clause that allows a federal parliament or a provincial legislature to ensure that a law operates notwithstanding rights that otherwise exist under the charter and the way that courts would interpret those. So on a basis where they would have to renew that every 5 years, they can end up saying that they're taking the view at a democratic level that they're going to override this right or freedom. And they're doing that in the Quebec context out of a very different sense on religion in the governmental context, and where they take the view that it's essential that everyone in certain public offices appear entirely without any religious symbols or appear entirely secular. And this isn't the view that most of us take in Canada. We would normally take the view that it's possible for somebody to be wearing a religious symbol, but still to be applying government policy while working in a government job and go into a government office, there will be people wearing a variety of different religious symbols. That's something that would be part of them. But as government employees, they're carrying out their work in a responsible way. And that those from other religious traditions or no religious tradition who appear before them don't have to face a concern because somebody is wearing a religious symbol. And so under the Oakes test, if this were to go to a charter analysis, my view is that it would be very challenging for such a law to survive, because it is directly limiting religious freedom. And the idea of achieving neutral government actions with respect to those of various religious traditions or no religious tradition can be achieved in other ways other than by prohibiting the wearing of religious symbols by those occupying various public offices. But Quebec has essentially ruled out that charter consideration through their use at the present time of the notwithstanding clause to enforce a model coming out of a very different French tradition on religious freedom in the public sphere, I guess. And there can be a lot of discussion about that. I think people can and should challenge this, but they should do so in ways that realize that there's more going on than in the discussion of this issue in a context in the rest of Canada. There can be engagement with what Quebec is doing, but there's a bit of a particular context going on there that involves some very strikingly different assumptions, and there will need to ultimately be an ongoing engagement on that in other ways other than under the Charter, because of the way that Quebec has ruled the Charter out of consideration at the present time. But there may be ways to engage in a discussion on international human rights and the approach to religious freedom, things like that, in engaging with this particular law.
Because of the cultural context in Quebec, one can understand why it would be that perhaps they would not look favorably on the rest of the world or even the rest of Canada interfering in their view or their cultural understandings of these things. And so that creates quite a complex situation. Okay, let's go to the issue of COVID-19. You know, there's been a lot of government lockdowns, a lot of vaccine mandates and so forth. I've had a lot of religious people come to me over the recent months who've been very concerned about, they've been losing jobs and so forth because of their religious position. They outline a very strong religious position with respect to vaccines. And I have to say that I have some sympathy towards their position in that, this is not something that's taken lightly. It's been something that's been part of their may even be part of their religious tradition for a while. And so we've come up against this with COVID-19, but you make mention with respect to just the COVID lockdowns, and then maybe we can also look at the vaccine mandates.
Indeed. I mean, here's an issue when we're talking about polarization, where we've seen some pretty dramatic polarization on issues. One of the challenges in this area in terms of constitutional law and COVID restrictions of various sorts is that the policies have all been so fast moving and so fast changing that it's been difficult sometimes for the challenges even to be put in time before the government policy changes yet again. And so this hasn't been an easy area for there to be litigation in. But I think we can highlight how the reasonable limits analysis would affect some of the kinds of decisions that governments have made. And I was hinting at one of those earlier, where in some contexts, governments have imposed greater restrictions on religious gatherings than on secular events of an otherwise similar nature. And the United States has seen court decisions that have really struck at those kinds of extra restrictions on religious freedom compared to on or religious gatherings as compared to on secular gatherings, because that's an interference with religious freedom, and an example where clearly there's not respect for something like minimal impairment. But we've also seen examples of policies that were probably just irrational in some cases because they were developed very quickly, and then sometimes they were abandoned very quickly. The big example I would point to here is something like a restriction that barred drive-in church services where people were going to remain in their vehicles. So there's no prospect, as long as this is properly conducted, there's no prospect of COVID transmission occurring. And governments in some early stages had policies in place that banned these from occurring. And we didn't get court decisions on them so much as governments backing down, I think, after issues were raised. But had those gone to court decisions, these would be an example where there's probably no rational connection between the government limit on a right or freedom and the pursuit of any kind of government of objective of limiting the spread of COVID. It just makes no sense.
When that happened, it almost gave the impression that the government was just simply against religion. It's like not that they may not have necessarily thought of that, I don't know, but it was like, why such a response to the religious community on this? It definitely gave the impression that government was out to impose a restriction on religious community, and that we have not seen before I guess maybe we've seen it in certain instance, like, for example, the Jehovah's Witnesses during World War II and so forth, where there was a particular animus against a religious community. But there was, in recent times, certainly, we haven't seen that kind of thing. And I think this has really put the religious community, and rightly so, it seems to me, on guard with respect to decisions that are being made by bureaucrats and by government. And so I don't think this helped the government's goodwill.
Something like that certainly doesn't help with goodwill. I would draw a distinction between government policies adopted really early on, and then those that had where there was a chance to spend more time thinking about them and getting them right. And so if in the early days in March of 2020, some things went a bit astray because they're drafting something up quickly and it had some problematic effects, it could just be an error. But as things move on, you start to question that in different ways, and governments didn't promote goodwill when they took certain kinds of excessive steps, or when they restricted religious communities more than other communities, or other kinds of facilities or events. These have not produced goodwill, but as importantly, they've also probably not always respected the Constitution, and that's a problem. And people are also saying, well, it was also very difficult to challenge some of these, and that's also a problem, because you end up in a situation where people might be asking, well, was the Constitution of use? And we've seen that question raised. In some ways, the application of the Oakes test sometimes becomes layered with the use of all kinds of needs within the litigation process to put forward all kinds of evidence. And there can be some shortcuts to applying some of the rules within. And I keep referring to this issue coming out of minimal impairment of, did the government impose more restrictions on religious facilities or places of worship than on other places where people gathered? And anywhere where they did that, you have to have a pretty strong bit of evidence coming forward to conclude anything other than that there was a lack of minimal impairment in that. There's an interference with religious freedom that can't easily be justified if you're interfering more with religious gatherings than with equivalent secular gatherings. It'd be sort of a shortcut around some of those big evidentiary questions to ask that kind of question. And I'm glad that some of the US courts asked that as clearly as they did. And I wish we'd seen more Canadian courts get into that kind of question in a sort of a quicker way that would avoid some of the obstacles that existed to some of that litigation, it seemed.
I want to come to that issue right now, and that is, in Canada, we've seen the courts kind of step away in many ways and showed more and more deference to government. And I was speaking with a lawyer in Calgary just a little while ago who was telling me of a situation that he had a client that was wanting to get involved in. It was a young person wanting to get involved in sports. And I don't know if it was a hockey league or what it was, but he was unvaccinated. And so he wanted to get wanted to appear before the court as soon as possible so that the child would be able to get involved in the activity. And the earliest, so this was back in January, and the earliest date that the court gave him was November. And well after the whole reason as to why you'd want to get a court review of this matter would have been gone. And so it's kind of like, and then he ended up getting another application. And when he appeared before, kind of like in a pretrial meeting with the judge made it very clear that, we're not interested in litigating the science of COVID. And there's this reticence, it seems to me, in the Canadian courts to have looked at the substantive freedom issues because it almost seemed like they did not want to be seen as going against science.
So I'll say deference to government is a tricky thing because sometimes there can actually be good reasons for deference, and the institutional capacities of courts to evaluate the entirety of a government policy can be limited just by the nature of what courts are. It doesn't say they should never ask the big questions, but it can be challenging for them to do so. And there can be reasons why they sometimes defer to governments on various big issues unless there's a really good evidentiary record put. One of the implications is that it's important to put court challenges in ways that don't necessarily hinge upon asking a court to make really difficult decisions that are beyond what a court's going to be able to do. I mean, to ask a judge to evaluate all of the science on COVID is a big ask, and it's not going to be a quick court hearing if that's what it is. I mean, if someone wants to litigate a case that hinges upon that, they need to be ready for a very lengthy court proceeding. But there can be other questions asked in easier ways sometimes that don't necessarily ask the court to engage with that big question, but that ask, is there a reasonable way of accommodating a particular belief in a particular circumstance? And at a practical level, that's often going to be the easier way to litigate a case.
Right.
Courts will always avoid answering more difficult questions than they need to answer. And we're lucky that they do so because we've got enough delay in the court system as we have it. So in some senses, I guess, I mean, there's a lot of different things to balance here. We don't want courts to take unquestioning approaches to big issues, but they do face a more challenging question when they are considering big issues, and that can take time, and it takes the right kind of case being put forward. But courts can also work even within not always questioning the big issues in ways that offer protections to individuals, and that's the kind of strategic approach that I would hope that lawyers would take to various issues that arise, realizing the position that courts are in a sense.
But yet there is that, as you pointed out, a distinct difference with how the courts in the United States have dealt with it compared to what seems to be, at least in this early stage, what the courts in Canada have had. Like, in other words, I wonder if the courts may have been oversensitive in Canada vis-a-vis what we've seen in the U.S. Like, the U.S. seems to have been willing to give or balance the issues, it seems to me, between what the government wanted to accomplish and what the religious community wanted to accomplish. And it seems to me there's been a bit more balancing going on there than what we've seen so far here in Canada.
Indeed. So, I mean, there are various questions that we're going to have to be asking pretty seriously in the years ahead out of the experience of what occurred. And various questions to ask about the way courts in the US approach things differently than in Canada. Some of those would be about when were courts ready to get into the bigger questions. The examples I'm citing from the US would also be an example, though, of US courts being willing to find practical ways of dealing with something without having to have an extended hearing. So something like this issue of there are more restrictions on places of worship than on a neighboring shopping mall, or maybe even more significantly than on a neighboring concert hall. Well, that just doesn't make sense. Even if you don't raise questions about the larger government claims about the policy and about the science, there are ways of getting into the questions that US courts seem to have found more easily than Canadian courts have. And we do have to ask some questions down the road on why Canadian courts didn't identify all of the same issues that U.S. courts did in some of the situations that seem pretty similar. There are a lot of questions to ask after this on how did Canadian courts do relative to American courts, for example.
Then we have the whole issue of the religious objection to vaccines itself. And did you have any thoughts on that one?
Well, I mean, that's a challenging one.
Yeah.
And it depends on the exact context in which it arises. And clearly there can be a religious freedom right that arises in relation to an objection to a vaccine. This isn't a view held by very many religious traditions, but within some religious traditions, there can be such an objection. And governments to varying degrees have suggested a willingness to accommodate that in those rare instances where it arises, but whether they end up doing that in ways that fully respect religious freedom, considering also the reasonable limits, that will be a question in the years ahead as we see all of the longer term decisions around vaccine requirements, I guess. But it does present a very challenging question, but one that also doesn't arise in that many contexts. So it's a little bit like the Hutterian Brethren case. Can you accommodate a fairly small number of people who have a sincere religious belief on an issue that does present some challenges for others, and that's what governments and courts need to wrestle with. One of the recommendations I offer at the end of the paper, though, is that one of the ways of heading off a lot of issues and violations of religious freedom is for governments to be more engaged with people from religious traditions, and for people from religious traditions to be more present in the public square generally, as a step for them to take, but also for governments to actively be trying to engage with people from religious traditions on various issues, just so they can understand what the claims are in the context of a government bureaucracy that might not even understand the issues. And we've seen examples I've written in the US context of different state governments in the context of 50 different state governments. So you have all these, in the old line about it, all these laborious laboratories of experimentation within federalism. And some state governments in the US engaged very directly with faith leaders around the impacts of different COVID policies on faith traditions, and others didn't. And you see some very different outcomes in those situations in terms of what policies were adopted, the challenges being put against those, and the goodwill that does or doesn't exist now. And even on the most challenging of issues, I would say the place to start is probably for governments to be talking with those who hold a view that might seem really challenging, to see, is there a way to work out a solution where everyone can live together as good neighbors? And in the context of religious freedom, this is something we owe to one another, to talk with one another, to really try to understand where others are coming from, even where there's something where we may feel initially some strong disagreement with some position. Well, try to understand where it's coming from, and if there's some reasonable way to accommodate that, and we'll be a lot further ahead.
Thank you so very much, Professor Newman. This is excellent. It's a great point to end on for us to be able to work together and to be able to have the discussions. And I want to thank you for watching Freedom Feature, where we are involved in trying to help you to see the complexity of all the various issues that we're dealing with: freedom of speech, freedom of conscience, inviolability of the person. And it's so great to have people like Professor Newman to help us to understand what exactly we're up against. And I thank you so very much, Professor, for being willing and joining with us here today to have this great discussion. And I want to congratulate you on a great paper, and we'll have a link to that paper right here underneath this video so that those of you who are watching can access it. And with this great primer, you'll be able to really get a deep understanding of the complexities of the issues of freedom, and in this case, particularly the issue of religious freedom. And we want you to recognize that these issues are not something that can be easily put off, but we need to ensure that we get to understand the other person who have a different view than us. And that's one of the things we're all about here, is that we are willing to address issues that maybe not everyone will agree. You may not agree with our discussion here today, but you have an opportunity to at least understand where we're coming from. And in this case, where we have a professor who's outlining the law and understanding the law. And we want to thank you for taking the time to be with us, and encourage you to go over to our site at firstfreedoms.ca, sign up for our newsletter. And until next time, I'm Barry Bussey. The fight for freedom consists not only in the legal battles in court, but also in the battle of ideas at the universities and in the media. It takes time, effort, and money to keep on top of the debates for freedom. Your donation allows us to keep fighting for all Canadians. Firstfreedoms.ca